Greetings and welcome to the webinar. My name is Tanisha Sellers and I am the Rose Community Transformer Coordinator at Reaching Our Sisters Everywhere Incorporated. And I currently sit on the Breastfeeding Workplace Constellation with the United States Breastfeeding Committee. I'm going to start us out with some context on the experiences of breastfeeding employees of the United States before passing the baton to this incredible panel that we have today of legal experts who will help you understand the legal landscape surrounding breastfeeding employees and how you can support families as they transition back to work. Jessica Lee is a staff attorney from the Center for Work-Life Law. We'll talk about the fair labor, about Standard Acts break time for nursing mothers provision. Galen Sherwin, who's our senior staff attorney at the American Civil Liberties Union, will discuss protections for breastfeeding employees under the Title VII of the Civil Rights Act. And Sarah Braffman is the senior policy counsel and director of the DC office at Better Balance, will share about the state laws that impact breastfeeding employees. And last but not least, Jessica Lee will join us again to discuss family leave and federal income replacement. Finally, our panelists will walk through common scenarios for employees during the pandemic and the steps you can take to secure accommodations. So for today's session, all participants are in listen-only mode. We will have about 15 minutes or 10 minutes for questions and answers at the end of the presentation. However, we hope this session will be as interactive as possible, despite the virtual format. So please share your insights and your questions as they come up for you during the session. Here's how you do it. Go to the control panel on the right of your screen. If you don't see it, it may be minimized. Click on the orange tab and it will pop back up. If you scroll down below the audio section, you'll see a tab for questions. When you click on it, it will open up a box for you to type in. If you have any webinar related tech problems, please send an email to office@usbreastfeeding.org and our staff will do their very best to help you. Next slide. So again, my name is Tanisha Sellers and I work with Reaching Our Sisters Everywhere and I am the Rose Community Transformer Coordinator. With this webinar, we do understand that it is and not so easy one sometimes for especially what's going on. So we would like to actually take maybe about 20 to 30 seconds to maybe just hold space for our essential workers, our moms and our families, our heroes, our first responders, and everyone that is out that is making things possible. So join me as we hold space for about 30 seconds for you and your families. Thank you. So let's put this webinar into scenario and let's think. We have one scenario of a U.S. Air Forceman, U.S. Air Forceman airman who was in need of pumping brakes. She was told she shouldn't get time to play with herself. Her name is Sarah. Sarah faced hostility from the moment she returned to work after having her baby when she was an active service airman. They didn't think anyone deserved to have 6 weeks off for having a baby. She was bullied for breastfeeding, and although she had rights under the Air Force instruction on breastfeeding, Sarah found her supervisors and coworkers don't know it, don't care to learn, and also think it is a waste of resources to have an airman pumping or nursing. Sarah was told to feed her baby formula given assignments that couldn't be completed while pumping, and prohibited from storing her breast milk in the freezer. The room that she pumped in didn't have a lock and no privacy. It was an equipment room, and people were walking in almost daily on her. One supervisor told her that she was out of uniform and had to pump with her shirt on. Another said she shouldn't get time to play with herself. A lot of people may not, maybe a lot of people, maybe not a majority, but a noisy minority think women should have to get out if they want children. But no one suggests men don't become fathers while they're in the military. In part because of the discrimination she faced, Sarah left the Air Force. This was an interview done by Sarah on October 9, 2018. As you can see, discrimination has been going on from the military to in the hospitals to workers who work at McDonald's and students all across the nation. And during this pandemic time, it has become even worse. So for today, you have expert panelists that's going to help us be able to navigate that and to help our families and to help you to be able to help your families figure and navigate through feeling safe to pump at work, being able to empower themselves and have their voice to speak up, and making good decisions and educated decisions for them and their family. As we go throughout the presentation, we would love to hear from you. We would love to know what your thoughts are. Please feel free to share it with us here at this link at breastfeeding.org support stories at USBC or throughout the chat. We encourage you to share any thoughts, even if it's just one word, as we go throughout this presentation today. Next slide. So starting at the very beginning, we know that mothers are separated from their babies for a lot of reasons. In the US, majority of children under the age of 5 in some type of regular child care arrangement, usually because a caregiver has returned to work or to school. The fact is that employment is the norm for women of childbearing age. 62% of women return to work before their child's first birthday, with 23% returning within 2 weeks of giving birth. And we know that some groups are disproportionately affected. For example, African American women return to work on average 2 weeks earlier than women from other racial and ethnic groups. A lesser known fact is the fact that 26% of undergraduate students are parents of dependent children, and that half of these students have children who are 5 years old or younger. These circumstances have a significant impact on the breastfeeding experiences. No matter where they are or what they're doing, breastfeeding mothers must pump breast milk about as often as a baby usually eats. This is critical for her to maintain her milk supply, ensure that there is adequate milk for her baby while she's away, and to avoid leaking, inflammation, and infection. And we also know that more than 3 out of 4 people working in the healthcare industry are women. So as all of we are well aware, there's a particularly great need for workplace breastfeeding support and accommodations in these workplaces, and even more a greater need throughout this pandemic time in 2020. Next slide. And while it's true that returning to work or school shifts the breastfeeding journey, by no means does separation of a mother and her child equal breastfeeding cessation. Simple, inexpensive accommodations make a world of difference. Things like break time, a clean private space, and a safe place to store express milk might be all it takes to help a family combine breastfeeding and employment. And healthcare and lactation support providers, in particular, are uniquely positioned to provide support to families when they need it the most. In our audience today are hundreds of providers who touch thousands of families across the nation. We have an incredible opportunity today to connect you to the information and to the resources that can help breastfeeding families before, during, and after they return to work and school. We know that you wear lots and lots of hats and are asked to cover a lot of information and a lot of time with people you serve. No one is expecting you to become fluent in lactation or legislation because that is a lot. Rather, our goal today is to make sure that you have enough information to point families in the right direction. You are so often the ones that families turn to. So by assuring them that there are the legal protections on their side, as well as individuals and organizations who can provide the support they need along the way, we can create a stronger web of support for breastfeeding employees than ever before, especially now. The struggle is definitely real, but there are also solutions. Women with both adequate break time and private space to pump were 2 to 0.3 times as likely to be breastfeeding exclusively at 6 months. The goal here is to make sure that every mother and baby reaches their needs. So without further ado, next slide, I would like to pass it on to my colleague, wonderful Miss Jessica Lee, who's the staff attorney for Center for Work-Life Law.
Thank you, and thank you for setting the stage. This is a critical time for nursing parents, and I'm excited to be here with you all today to talk about the laws that protect them. So the first law we're going to talk about today is the federal law called Break Time for Nursing Mothers. You might have heard of this when it passed. It was a part of the Affordable Care Act. This is the only nationwide law that makes sure that lactating parents have access to accommodations in the workplace, specifically saying that they're entitled to break time and space. There are other laws, of course, that overlap with this, and we'll talk about that in a few minutes. So this federal law, it applies to every employer. It requires employers nationwide to provide their eligible employees with reasonable break time as needed. And by as needed, this is often a tripping point. I mean, as needed, as often as that lactating parent needs to pump, it should be provided. Reasonable here means that it can't be an undue burden on the employer in light of their size and their finances and what is being requested of them. It does not mean that an employer decides what a worker's body needs or what her baby needs. The law also requires the provision of a private space for expressing breast milk. That space should be free from intrusion. For example, having a lock on the door or a sign that is strictly enforced saying that nobody should be able to enter. Curtains on the windows, so it should be free from view as well so that folks aren't able to just come peek in. And that space should not be a bathroom. One big catch, though, for all of this is that the break time as needed and the private space free from intrusion and view that's not a bathroom only has to be provided for up to 1 year after birth. I should note this break time, the break time that's provided under this law is typically unpaid. That said, if an employee is working while pumping, they should still be paid for that time. That's not really a break. If they're not fully relieved of their duties while they're pumping, they should be compensated for that time. And if an employee is paid for certain breaks and pumps while taking that break, they should still be paid. So for example, if somebody is paid during their lunch breaks and they decide to use that paid lunch break to pump breast milk, that should still be paid. It's not suddenly an unpaid break just because there's pumping going on. Next. Now, while this law applies to employers nationwide, there are a lot of employees that are left out from it. So most hourly workers are covered, but there are some big groups of workers that are not covered by this law. And that is because this isn't just a standalone law that provides break time and space to lactating workers. It actually was attached to the federal law that requires employers pay certain workers overtime. So typically, if you're not eligible for overtime, you're not protected by this law. But let's just really quickly, some of the folks who are left out are teachers, registered nurses and doctors, certain transportation and agricultural workers, folks who are working on a commission in a retail setting, and managers and professionals who are supervising. There are many categories of workers left out of this law. You can get in touch with the center or call USA Wage for more information. But I will say the vast majority of folks are indeed covered. Next. So while most folks are covered by this, there are some exceptions. One of the really frequent misunderstandings we see about this law is that folks think that it doesn't apply to small businesses. And so I want to set the record straight here. The break time for nursing mothers provision applies to employers of all sizes, and it includes those in so-called essential industries. If somebody works for an employer that has fewer than 50 employees, they may be able to argue that providing break time and space causes a hardship. If they are at one of those small shops for fewer than 50 employees and it causes an undue hardship in light of the size of the business, the number of workers, the finances of the business, then they might be able to be exempt from this law. But I will say that's a pretty high bar to meet. USBC and all of our partner organizations on this team today have seen case after case where we've been able to figure out creative solutions for providing break time and space for nursing mothers. And so while there is an exemption available to those who have fewer than 50 employees, we argue that it should be very, very rare for someone to truly be exempt. In light of COVID, I want to note two things here. One, again, essential industries are not somehow exempted. And two, while the COVID crisis might impact whether or not something is an undue hardship, there are no COVID specific exemptions. So this law really has not changed at all in light of the pandemic. Um, but I'll give you two scenarios. Um, we've heard a lot of folks at grocery stores who've been told, sorry, you are an essential worker. We cannot give you the break time and space that you need. We're in the middle of a crisis. You're essential. We can't give it to you. That would not match the law. It's if nothing has changed there, there's still a large grocery store. Whether or not that worker is considered essential or not does not have an impact on their ability to get break time and space under this law. In contrast, say for example, you work for a really small mom and pop shop. They used to employ 6 or 7 folks. They were able to give break time and space as often as needed. And now there's only 1 employee and they're on the edge of going broke because all the business has dried up. They might be able to argue it. I think pretty much everyone on this call could think of 10 ways that they're not exempt. But it would really have to be that sort of a dire situation for somebody to suddenly be exempt. So the crisis has changed the context. It's made things harder for businesses, and that might impact the way they respond to accommodation requests under this law. But the law itself still has not changed. Next.
All
Now I'll
right.
turn it over to Galen. Thanks.
Thanks, Jessica. All right. Hi, everybody. My name is Galen Sherwin. I'm a staff attorney at the American Civil Liberties Union, and I work in the Women's Rights Project there. So I'm happy to be joining you all today. I'm ready for the next slide, and we'll get started. The main point of my part of the presentation is that, as Jessica just outlined, the Break Time for Nursing Mothers Act places an affirmative obligation, a duty on employers who are covered to take particular steps and provide particular accommodations for breastfeeding workers. There are also negative obligations that attach to employers, and that is the prohibition on discrimination. Employers cannot discriminate against employees based on sex. And the federal law that prohibits sex discrimination in employment is called Title VII of the Civil Rights Act. It applies to employers with 15 or more workers. So it's most employers in the country are going to fall under this, except for really small mom and pop shops. The prohibition on sex discrimination means treating a worker differently because of sex in a way that impacts the terms or conditions of the person's employment. And the reason this law is important in this context is twofold. One is, like Jessica was saying, there are a number of categories of workers who are not covered under the protections of the federal break time law. And so for those workers, it is really important for us to think about what are some other layers of protection that people have. And the other reason it's important is just that no one should be subject to discrimination at work because they're breastfeeding. That's a very basic statement, and everybody should know that there is protection against discrimination on the basis of breastfeeding. So the way we get there is that Title VII included an amendment called the Pregnancy Discrimination Act, and under that law, the prohibition on discrimination on the basis of sex was defined explicitly as including pregnancy, childbirth, and related medical conditions. And courts, even though this isn't spelled out explicitly, courts have started to recognize that this actually covers breastfeeding and lactation. So what that means is that employers cannot discriminate based on lactation or breastfeeding. The Pregnancy Discrimination Act also makes clear that workers who are affected by pregnancy, childbirth, and related conditions have to be treated the same as others who are, quote, similar in their ability or inability to work. So what that means is that there is essentially an obligation on employers not to discriminate based on lactation, and they can't treat you worse because you're breastfeeding. I'm ready for the next slide. So the key takeaway from that is that if an employer is not accommodating breastfeeding or lactation, that can be a form of covered sex discrimination. It can be illegal for illegal discrimination if other workers are given accommodations but breastfeeding workers are not, and there's not a good reason to treat them differently. And as I mentioned before, this is particularly important when the break time law does not apply. So some examples of what this would look like. A police officer who's requested light duty, meaning a desk job, because her bulletproof vest interferes with her breastfeeding. And her boss, her supervisor, accommodates workers who got injured on the job, but does not give desk duty to workers who are pumping. Another example, a flight attendant is not given breaks to pump on the plane. She's told you can't use your breaks to pump on the plane, but her coworkers are allowed to take breaks for any other reason, to go into the lavatory and put on makeup, to brush their hair, to sit and read a magazine. So these are all, these are two examples of different treatment based on the fact that the break is related to breastfeeding, or the fact that the need for light duty is related to breastfeeding. And the takeaway again is that employers have a duty to accommodate breastfeeding workers to the same degree as they accommodate workers, other types of workers, unless they have a really good reason not to. Okay, next slide. So I don't want to leave you all without pointing out that these types of failure to accommodate are not the only way that Title VII protects against discrimination at work. So there are different kinds of discrimination, and failure to accommodate is just one type. Other examples, the sort of very obvious example, when somebody discloses that they're breastfeeding or that they will need to pump breast milk and they are told you're fired. That still happens. Then policies that expressly treat breastfeeding differently than other conditions. So examples include exclusions from insurance coverage for breastfeeding related care, or again, permitting breaks for other purposes, but not for pumping. And then, the other type of discrimination that I want to make sure we put on the agenda here is retaliation. That is essentially when you complain against what you think is a discriminatory act, the employer is prohibited from punishing you for that. From basically taking any action that would discourage people in your position from complaining about what they think is discriminatory conduct. And then finally, sexual harassment, which is defined as offensive or sexual comments that in this case are related to breastfeeding that interfere with your ability to do the job or create a hostile work environment. So, an example there is a client that I worked with. Whenever she would go to pump, her coworker would make mooing noises at her. She also said he brought a cowbell one time. So this is obviously very derogatory, comparing her to a cow, and made her feel really horrible at work. All right, so next slide. I'm going to pass this off to my colleague Sarah, who's going to talk about state pregnant worker fairness laws, which again are another way of sort of filling in the gaps left by the federal break time for nursing mothers law.
Thanks so much, Galen. Hi, everyone. So to add to what Jessica and Galen have already spoken about, so far we've covered federal laws, and what I'm going to talk about now are something called pregnant workers fairness laws. That's kind of how we refer to them as a grouping. And these laws are in addition to the federal laws that we've discussed. So they only add and fill in additional protections. They don't take away any protections. And 30 states and 5 cities have this type of law. And what the law requires, generally speaking, is for most of these states, the framework is that employers have to provide reasonable accommodations for limitations or medical needs that are related to pregnancy, childbirth, or related medical conditions, unless it would cause an undue hardship on the employer. And this framework might be familiar to some of you because it's very similar to the framework that's in place for workers with disabilities. Under the law, pregnancy is not a disability, and so that's why these laws were enacted to really make clear that employers have an affirmative obligation to provide reasonable accommodations unless it would be really difficult or really expensive for the employer to provide. This is a list here of all the states, as well as Washington, D.C., that have this type of law, but there's a link below if anyone wants to look at each state in more detail, because they all vary a little bit. They might have slightly different employer thresholds applying to, some might apply to one or more, workplaces with one or more employees. Some might apply to workplaces with 15 or more employees. But for the most part, these laws cover a very wide range of workers. And unlike the federal break time and space law, they don't have as large of carve outs as that law does. And so if we go to the next slide, we will talk a little bit more about the lactation specific accommodations. So the federal law covers break time and space for lactation. Pregnant worker fairness laws are really wonderful because of how flexible they are. So many actually explicitly state in the law that lactation is a pregnancy related condition. Many specifically say that providing a clean space and break time is a reasonable accommodation. And listed out here are kind of the breakdown. So there are some states where it specifically says that you have to provide lactation accommodations. Some states use the language that's very similar to Title VII, which Galen just discussed, which is that lactation is a pregnancy-related condition. So anytime that a law says that an employer has to provide accommodations for pregnancy, childbirth, and related medical conditions, we feel very confident that that applies to lactation as well. And unfortunately, there are a couple states where it may not apply to lactation, but we always encourage folks in any state to try to push for lactation to be included. Some of these laws are just earlier laws. Most have been passed in recent years, but some of these are a little bit more narrow than most of the laws. If we go to the next slide, I just wanted to talk a little bit about what it looks like to go through this process of seeking an accommodation and what we're talking about specifically with respect to lactation accommodations, because it can indeed go beyond just break time and space. And that's what's really nice about these laws, in addition to being an affirmative right. So the first step is really just to ask your employer for an accommodation based on a limitation, a medical need, a condition related to pregnancy, childbirth, or a related medical condition. And why it says here that it doesn't need to be a disability is that these laws are, certainly if you have a pregnancy-related disability like gestational diabetes, like preeclampsia, you can seek accommodation under this law. But what's really important is that most medical needs may not be themselves a disability, right? Someone may have a medical need to drink more water, but it's just related to a routine pregnancy. It's not necessarily a pregnancy-related disability. And so under these laws, you can ask for an accommodation just based on a medical need that you have. Examples of lactation accommodations specifically certainly include break time and space, but they might also include access to personal protective equipment if you need that so you feel comfortable breastfeeding. They might mean modifying a workspace or modifying your schedule so that you can breastfeed when you need to. It might mean temporarily transferring to avoid risks related to breastfeeding or asking for light duty. Sometimes there's examples of officers who it's very hard to wear a vest and be on duty and be doing street duty, but and patrolling, but they might be able to do light duty and while they're breastfeeding. Or in some cases, teleworking might be the answer. If it's really not conducive to be able to breastfeed, you might be able to work from home for a period of time if you're able to do that, and it doesn't cause an undue hardship. These are determinations that are made on an individual basis, and your employer is supposed to work with you to come up with an accommodation. Even if the first accommodation that you suggest isn't really working out, your employer should suggest an alternative to you unless it's, again, really difficult or really expensive for them to provide. And in a lot of cases, the laws do allow for the employer to ask for a doctor's note, and we do have a resource at the end where it's your provider can write an effective note for you. But I did just want to flag that sometimes these laws can allow for an employer to ask for doctor's notes or provider certification as well. And next slide. So just very, very quickly, getting to other state laws that might be helpful. So on the state level, there are many states, most states in fact, have a state level equivalent of the anti-discrimination law that Galen spoke about. What's nice about these laws are sometimes the state law has a lower employer threshold than the federal law. The federal law applies to employers with 15 or more employees. You might have a state that has a threshold of 1 or more employees, which means it covers all workplaces. And that's just important to remember for those smaller workplaces, that those anti-discrimination laws may provide more protection. The other thing about anti-discrimination laws and the state pregnant worker fairness laws is that oftentimes they have very strong enforcement. And one of the issues with the federal break time law is that the enforcement of that law, unfortunately, can be pretty weak, but the anti-discrimination laws and the state level laws can sometimes provide better enforcement. The same goes for break time and space laws. Some states have individual break time and space laws as well. And then another law that isn't squarely a breastfeeding law, but I think is really important to mention on this webinar, are state and local paid sick time laws. And these are laws that provide a sort of short amount of time off. Often the average is around 40 hours. You can earn up to 40 hours a year, but these are laws that can be used for your own illness, but also wellness appointments. They can be used to care for children and oftentimes care for a broad range of loved ones. And I want to just flag, because it's paid time that you can be using if you're eligible under one of these state or local paid sick time laws. And we provide a chart at the end as well, so you can see if your state or city has a law. And just as an example, you might want to use it to visit a lactation consultant, or if you have any other sort of breastfeeding related medical need. Let's say you get mastitis and you need just a couple days off to deal with that, you could be able to take that time off, have it be job protected, and have it be paid. And now I think I'm going to turn it back to Jessica to talk about federal income replacement and leave as well.
Thank you. Next slide. Great. So I just wanted to very quickly raise for you all that there is a fantastic federal law on the books for those of you who aren't fortunate enough to be in one of those locations that has an emergency sick leave law. This is called the Families First Coronavirus Response Act. There is a leave option that is currently set to expire December 31st, which we're all very, very concerned about. Hopefully it will be extended in the new year, but for now, there are just a few weeks left that you could use this paid time off for. This paid leave applies if the employer has fewer than 500 employees or if they're a government entity. So for example, folks working for public schools, public parks, they would be working for an employer who is covered under this law. But it may not apply to healthcare providers or emergency responders. So the FFCRA provides emergency paid sick leave for your health if you're subject to a quarantine or isolation order from the government, or if you've been advised to quarantine by your healthcare provider. And it also covers time off if you're seeking diagnosis for COVID-19 symptoms. So for example, probably the most applicable example here, if you are pregnant and your doctor has advised you to even more strictly isolate to protect yourself and avoid the risk of being COVID positive when you deliver, you, until the end of the year at least, are eligible to get 2 weeks fully paid emergency sick leave if you work for one of these covered employers. Can you click ahead? Okay, so that's 2 weeks of full pay up to $511 daily. And then next, even if, say, you're post-birth, you have a newborn and the place that you hoped to bring them for childcare is closed because of the pandemic, and you can't get back to work as a result. If you're caring for a child whose school or place of care is closed or unavailable, you would be entitled to up to 12 weeks if you haven't used up all of your FMLA time. And that's at 2/3 of your usual pay, up to $200 daily. There's a lot of nuance to this, a lot of details, but I just want to flag for you because the time is running out and folks who don't have other paid leave can rely on this for a few more weeks and hopefully again in the new year. If you have questions, there's a link at the bottom of your screen. Next. One other note, if anybody does have to leave their work or take an unpaid leave to protect themselves due to health conditions, which could include pregnancy, there is pandemic unemployment assistance currently available, and I'm fairly confident will also be available in the new year. So if, for example, you have a high-risk pregnancy or still have been advised to isolate following birth and you are unable to get the accommodations you need for whatever reason, or you want to quit your job to protect your health, there is some additional assistance that typically isn't available to folks who have to quit their jobs. Thank you. Next. And there's been an extension on unemployment. So here are the strategies. That's okay, you can move ahead. We're low on time. Here are the strategies that we want to remind folks of. First of all, again, maximize that available leave and paid time off, either state and local leave or federal leave. Next, ask for accommodations early. We encourage folks to do that before your first day back at work or before starting work. We have a little guide on COVID work issues for lactating workers. You'll also see at the end of our presentation, we have a guide on how to talk to your boss about this. I encourage folks to utilize that as early as possible before it's an emergency. And if at all possible, document your request in writing. Maybe you have a conversation with your boss, then afterwards summarize it in an email, but get as much in writing as you can. And then if you need help, especially if you're using one of those reasonable accommodation laws, this is often, but not always required, you might want to get a doctor's note to help back up the request. And here is a link for a guide to writing effective doctor's notes. And of course, getting back up means feel free to call us, those of us who are on this presentation right now. Next. Great. Now I'll turn it over to talk about some real life situations.
Thank you so much, Galen, Sarah, and Jess, for all of that great information. So let's see if we can apply some of those things looking at these scenarios. So in scenario one, we have Sharon, who's a registered nurse, told her manager she needs breaks in between COVID patients so that she can decontaminate and pump. The manager said she didn't think it would work out because there would be no one to cover her additional break time needed for pumping, especially because her breaks would need to be longer to decontaminate. The manager told Sharon they would discuss it when she returned to work. What are Sharon's options? So, Galen, what do you think about this scenario?
I think this scenario has a lot in it, and it's probably a situation that's being faced by a whole lot of essential workers in this time. So I think it's a really helpful scenario to go over. I think it raises some questions that I would want to know answers to. So, you know, if Sharon were to call me and say, what are my legal options? You know, obviously first and foremost, you know, she should learn her rights and make sure that she's has a firm grasp on which of the laws that we were talking about on this presentation might apply to her, and then come back to her employer kind of prepared, armed with that information, prepared to negotiate. So the first stop is always, can I go back to my manager if there's a way to kind of go up the chain to try and get what I need to do that, and to do that early. Her manager saying, you know, we'll wait and discuss this when you get back to work. Is that going to work for her? No, because, you know, when you need time to pump, you need the time to pump right then. It's not really an option to just deal with it on the fly. So that's why, you know, what Jessica was saying about doing this as early as possible is so critical. In terms of the laws that might apply to her, so as Jessica was saying in the beginning of the presentation, unfortunately, the break time for nursing mother's law, the federal law, does exempt registered nurses. So she would not have the benefit of that protection here. And that is really unfortunate, but it's not the end of the inquiry. So what state does Sharon live in? And is there a state break time law or a state pregnant workers fairness law like what Sarah was outlining before? So it's critical to kind of know the answer to those questions. It's also important to know, to the extent she can find this out, how the hospital is treating needs for breaks for other purposes or other types of accommodation requests right now. So that is what's relevant to the assessment of whether the treatments she's getting might be discriminatory. If they are treating other requests for breaks better and saying, sure, fine, that's a different question. And then finally, I'll just say that, you know, even under the state laws that might apply here, there are usually the same kinds of undue hardship exceptions that would kick in and potentially be applicable here, given that these times are so, you know, unprecedented, and the need for healthcare workers is something that you know, the employer can at least say might be too much for them to try and work around. So I'll stop there and open it up to others. I also want to say that there may be, in terms of the additional COVID-related relief options, you know, if none of these options work, she can always consider those. But I think, you know, obviously we want to avoid having people having to take unpaid time off or even partially paid time off if that's not what they want to do. So I'll stop there, and if any of the other panelists want to jump in, please do.
Yeah, I think you raised a very, very important point about the fact that this might be a crisis setting where the employer can claim an exemption. But I do want to give just a couple examples of things that Sharon could ask for that might be reasonable. So if she's in a state that has one of those Pregnant Worker Fairness Acts, and we'll give you all the links to figure that out at the end of the presentation. If you're in one of those states, she could, for example, ask for reassignment. So if nurses freely sort of move around different units, if it's possible for her to work on a different floor while she's still pumping this regularly, because they're just not going to be able to give her that time, that might be an alternative accommodation she can ask for. So under these Pregnant Workers Fairness Act laws, it's not just saying, oh, well, it's hard for us to give you that coverage. Sorry, we can't do it. Even if that's true and it's really impossible to do that, they need to look at plan B, plan C, and plan D until you reach a solution that works. So that might be reassignment, that might be working a different shift that's easier for you to get that time off. That might be relocating a lactation room. There are all sorts of different ways. And if you are fortunate enough to be in one of those states, I would definitely think of plan B, C, and D creatively to try to find a solution that could work.
The only thing I'll add, I think that's exactly right, Galen and Jess. We've had a couple of people who are nurses who have been able to move on to a telehealth role, both for, around fear of exposure and around, certain pregnancy and breastfeeding needs. It's not necessarily the case that Sharon would want to move into that kind of role, but I know that in healthcare, there are some spaces being made specifically for pregnant nurses, for other healthcare workers who might be immunosuppressed, to move into a telehealth role. And that might be something that Sharon can ask for as well, especially in a state with a pregnancy accommodation law.
Sounds great. I think the rule of thumb that we've gathered from all of you is make sure that we go early and talk to the employer is one of those things. And to use these resources, I see Cheryl has dropped one in at Office of Women's Health. So this is a scenario when definitely maybe going there and getting creative would work. Let's look at scenario 2. So in scenario 2, Renee works in a store, and after she requested a private place to pump, her employer said to use the staff break room. Everyone in the store uses the break room. It is not ventilated and the door doesn't lock. Her coworkers frequently pound on the door while she's using the room. Renee doesn't feel safe pumping in that room and is extra concerned about the level of exposure she is facing at work as she is just a week postpartum. What are Renee's options? Sarah, what do you think about this one?
I think I'm hopeful that Renee has some good options. So I want to start with being hopeful. Number one is going back to Galen's point, which is really thinking about how Renee is covered legally. And just setting aside, and I want to walk through the law and coverage. There's nothing that says just because there isn't a law. So for those of you who are in states where there may not be a state pregnant worker fairness law, or you may not be covered under the Fair Labor Standards Act, there's nothing in the world that says just because there isn't that, you can't ask a manager and try to work it through. Maybe there might be a private policy, but thinking about where the law can be of help, I think it seems likely that because Renee works in a store, she is likely covered by the Fair Labor Standards Act, so by federal law. I'm hopefully going to assume that she works somewhere with 15 or more employees and that she's covered by federal law. And then it would obviously be important for her to know what state laws cover her. The one thing I want to flag about the federal law is that it's very clear under the Fair Labor Standards Act that the space has to be shielded from view and free from intrusion from coworkers and the public. And her coworkers are banging on her door. She doesn't feel safe. And so I think she has very good standing to be able to say, this really isn't what the law contemplates, and my rights are very clear in that regard. What I do want to flag, though, is that the law doesn't say that there has to specifically be a lock on the door, and it doesn't say that it has to be a dedicated lactation space. So that the piece about being free from intrusion is very clear, but these other pieces are not as explicit. It also, the federal law doesn't even specifically say that the room has to be super sanitary, but I think certainly you can argue that the law contemplated it being sanitary because it says it can't be a bathroom, and some of the state laws are very clear that it has to be a clean sanitary space other than a bathroom. So that's another piece, just flagging the state laws. But kind of talking through her options. So I think step 3 are thinking through what her practical options might be. So number 1, I think is discussing with a manager again as early as possible how to make this break room space more viable for breastfeeding. Maybe put in a clear reservation system if she knows what her schedule is going to be for pumping. She can always ask to put a lock on the door, put a sign on the door, ask for ways to feasibly put in better ventilation. So that's step one if she wants to ask about that space in particular and making that a viable space. Secondly, she can ask for a different space if it's available. Third, if that's not possible, she can ask for the creation of a temporary space, maybe getting some curtains and drapes and putting up a space that is reasonably priced, but would be a much more comfortable space for her. If she works at a store that's a franchise, maybe she can temporarily transfer to another store if that store has a better space and maybe it would be more conducive for her. Or maybe Renee modifies her schedule to work at less busy hours so her coworkers aren't banging on her door all the time. If she's covered by a state PWFA, she can also, seek accommodation for leave as an accommodation just until it says here, she's just a week postpartum and she's nervous, particularly about how young the baby is. Maybe she goes on leave for a little bit until the baby gets older and she feels more comfortable since it's so soon after. And the other thing is to explore, since she is so soon after postpartum, she may be eligible for a state paid family leave law, or she may be eligible for disability leave under a state law. And that might be helpful for her here. And if she's not in one of those states, there might be a state sick time law, which is those laws that provide for a shorter amount of time, but at least might give her a few more days postpartum that might be helpful to her as well. And Jess and Galen, please feel free to jump in with other thoughts.
Yeah, I mean, I think that was a really thorough answer, and I'll just add that, we're talking here about a lot of the options that would allow her to continue getting paid. If all of those don't work, there is always, if she's eligible for it, the federal Family and Medical Leave Act, which provides for 12 weeks of unpaid parental leave to care for a newborn. So that's something that, I'm assuming that because she's back 1 week after postpartum, she either didn't know about that or she's not qualified for it, or maybe she used up all her FMLA previously with other health conditions or other sick family members. But I want folks to just keep that law in mind, and that law, if you're eligible for it, applies kind of regardless of all of these sunset periods that exist right now under the sort of COVID relief laws, which are more temporary.
Jess, do you have anything to add?
No, thank you.
Okay. Well, we'll go on to scenario 3. In scenario 3, Monica works from home while caring for her infant and school-aged child. Instead of taking pumping breaks, she nurses her baby while working. Her boss informed her that she cannot nurse her baby while working and that she is only allowed to take 2 15-minute breaks during her workday at 10 and 4. What are Monica's options? Jess, I think you'd be best
Thanks.
to kind of
So
help us with this.
yeah. So first of all, we've been saying again, if you want to take leave, you don't have to, but if you want to take leave, know it's available to you. So if this was somebody who had called me right now, and I know she's taking care of her school-age child, I would be sure to mention to her that it might be possible to get leave at 2/3 pay if she wants it. But focusing on the breastfeeding, from a non-legal standpoint, the first thing I would do is to remind the employer that breast or chest feeding is often quicker than pumping. And it's certainly quicker than having to travel to a pumping space like most folks have to do at work. And breastfeeding, feeding your infant while working will typically mean that you are being more productive because you have to take less time off. And frankly, if parents are like me, I feel better when I get to see my kids for a few minutes during the day. But from a legal perspective, I'd answer this slightly differently based, of course, on which laws cover the worker. So again, go to pregnantwork.org /workplace lactation laws to see what you're covered under. If you're covered by one of those state level reasonable accommodation laws, um, this is easier. The reasonable accommodation you would want is permission to breastfeed as often as needed. It doesn't matter if there's a rule saying that that's impossible. You're asking for a reasonable accommodation to change the rule. And frankly, that seems pretty reasonable to me. If you aren't covered under one of those laws, you're probably protected by the federal break time for nursing mothers provision, or maybe a state law which says you're entitled to pumping breaks. The right to lactation breaks as often as needed on the worker's schedule, not their boss's schedule, is protected by those laws. But of course, because those laws usually only mention pumping, it can be a little bit of a challenge to argue with an employer about whether breastfeeding, whether direct feeding of a child is covered. From a just very practical standpoint, many folks just keep taking their so-called pumping breaks and don't reveal to their employer that they're removing milk by using a baby instead of by using a pump. But I should say, regardless of which category Monica is in, she still has a right to not be discriminated against. So typically, I would say, it's unfair to scrutinize the details of her workspace. They aren't doing that to other folks. But I sure hope not. The boss likely doesn't know when Monica's coworkers are eating at their desk or taking a quick bathroom break. So it may be discrimination to over scrutinize Monica while she's working, and to say who can be with her while she's working, or what she can be doing with her own body while working. So this scenario is very likely sex discrimination. And I would definitely feel free to call us to talk it over, with the specifics of your situation in mind, if this is sounding familiar. I should say one more point. If because Monica's working while breastfeeding, she should still be paid. That's not really a break, and it's it should be treated as such. So if you're working while breastfeeding or if you're working while pumping, that's still work. It should be paid as work. It should be treated as work and should not be scrutinized in the way a break is scrutinized. I'll also add one thing, which is I've worked with a few students now who've faced similar situations where they've been told to they can't turn off their camera while breastfeeding, or they can't take breastfeeding breaks. I would also, that has also in the past been sex discrimination. If you visit pregnantscholar.org, there's a little bit more information, or you can get in touch with me.
So before Sarah and Galen give a little bit, got maybe 1 or 2 minutes. I wanted to kind of add in because this scenario kind of goes with one of our questions since we don't have a whole lot of time. But Sarah and Galen, when you address this, can you also address many mothers are fearful and feel that there is no teeth to the law and don't enforce it. So how can we help with that? How can they help with that, and maybe even relating it back to this scenario?
Yeah, that's a
Go ahead.
really tough issue. And it is true that that many of these laws don't have strong enforcement mechanisms, as was alluded to earlier in the presentation. So, I think that enforcement of the law is sort of through like a lawsuit, is always a last resort anyway. And so the starting place is always going to be communication with your employer to try and get the result that you want without having to threaten them with a lawsuit or any other kind of complaint. In this situation, because like Jessica was saying, it does really sound like this is singling out breastfeeding for higher level of scrutiny or rules than other employees are probably being subjected to. That does mean that she has these avenues probably internally to bring an internal complaint if she's unable to resolve the issue directly with the supervisor. So there are many workplaces have, most workplaces should have internal complaint procedures where you can make a complaint that you think you've been discriminated against. And those internal complaint procedures can certainly, oftentimes they're required that you go through them first, because you have to give your employer the opportunity to kind of fix the problem before you can, get relief in court in many cases. So, I would just, I guess, add that the lack of enforcement mechanisms in this scenario is probably less critical because of the discrimination angle. It does become really critical in the case of a straight up violation of, for example, the break time for nursing mothers law, because your only real recourse in that situation is to file a complaint with the Federal Department of Labor. And I think that there's mixed sense of how quickly and effectively they're able to respond to those complaints, although we know that they do try. So I do know that a lot of the more recent laws that have been enacted at the state level, there's been more of an intentional effort to make sure that those have stronger enforcement mechanisms. And I guess I'll stop there. And yeah, Sarah, please jump in.
No, I think that was great, and would love to be able to answer other questions as well, because I know we're short on time.
My very, very short answer to the question about enforcement is to please call our helplines if you feel like you've reached a dead end.
Yeah.
The majority of employers that we've worked with have they seem ignorant to the laws or to the seriousness of the laws, and are willing to change things once they better understand them. But we can talk you through all the various options that might be on the table for you.
Well, we are at time, and I think Jess is going to close us out with some refillers, but I just wanted to just say thank you to everyone, and wanted to just mention to one of the key things that is come out of all of this is to make sure that you go before you get ready to deliver if possible, and to make a plan so we don't fail. If you don't plan, then you fail to plan. But you guys get the point. But Jess, back to you.
Okay, well, I think if folks are up for it, in a couple minutes, we could still take some questions for the benefit of folks who are listening later or who are able to stay on the call. But for now, you do see on your screen, we have a lot of resources for further information, resources on COVID-19 work issues and about lactation accommodations generally. Please check out these resources. Next. We also have legal helplines on that last slide. So when we say, if you run into this issue, call us, this is where we want you to go. We often provide information to help folks understand their legal rights. We might be able to point you in the right direction, and might be able to help you problem solve some of these trickier issues. So please don't hesitate to give us a ring on our helplines. Or next slide, if you want to talk with the folks who are here or learn more about our organizations, here's the contact info aside from our helpline where you can find more about us and the work we do. So now I'd be happy to answer some questions if folks are still up for it.
Okay, I think we've still got quite a few attendees here, so we can start with some questions. So one of the questions that we got to was, or someone asked, I'm sorry, Cheryl, you did send it to me. Oh, do we have any questions? If you have any questions, feel free. There's one. Okay. Can an employer mandate the use of a designated pumping or lactation space versus the use of the employer's private or semi-private office? The question has been relayed to me that from an employee who would prefer to pump in her locking shared workspace with consent from her one shared office mate and has done so in the past, but a new manager believes she must use the pumping room. So,
I mean, I'll jump in. This is Galen. I mean, I think that that does fall in a sort of a legal gray area in terms of what any of these affirmative laws would require. They're not really very specific about that type of arrangement, but I think that it is a very reasonable accommodation to be requesting for breastfeeding. So it would be worth making that request. And there is, you know, for example, if other workers are allowed to take breaks in their own private semi-private locking offices for other purposes, then you know there's a chance that it could be discriminatory for the employer to refuse to provide that to this worker, this person who wants to use their office for that purpose. I think that there are sort of some valid issues that concerns that employers have about those types of requests regarding the comfort level of coworkers that they do have to be attentive to. So I'll just say that. I don't think there's a very clear answer, but I think it's definitely worth making the request, and you know, trying to push for what works for you, because it is a very reasonable request.
And I'll
Okay.
say, I think
Add,
that's right. And the a couple of additions to that. Some of the state level pregnant worker fairness laws do have a provision that says an employer can't force a worker to accept an accommodation that the worker chooses not to accept. And the kind of thinking about that is a lot of times, you know, workers might be forced out onto leave, forced to accept certain things. So I think in that circumstance, if a worker is covered by a pregnant worker fairness law in that state, that might be particularly helpful, even though other places it might be a little grayer. And then I know in New York City specifically, the enforcing agency is fairly clear that if a worker wants to breastfeed at their workspace, you know, feelings of discomfort and, you know, they don't like that coworkers might not like it, or whatever stereotypes there are not reasons to not allow the worker to breastfeed at their own workspace and have to be permitted to breastfeed at their own workspace. So that's just something I would flag in particular.
okay. We have another question that came in. It says, working from home, the sounds of pumping or a child noisily breastfeeding may be objected to by supervisors, coworkers, and customers, etc. How has this been handled by some workers? What principles or laws may be involved? Good question.
that's a really interesting question. I'll sort of point back to the last scenario, and just mention that you're right to take that time that you need, still applies, but in terms of what folks are comfortable with, I think it's kind of goes back to that last question of, you might want to ask for it as a reasonable accommodation, the permission to carry on, but I mean, I personally don't think it's objectionable or should be seen as objectionable, but I think that might be a gray area. What do other folks think?
It's really interesting. I mean, first and foremost, I hope that that worker feels like they can take the time they need separate from working.
Hmm.
You know, it's for break time and space, so they shouldn't be told that they have to be working and pumping at the same time. Um, and in fact, this might hit on, I think, another question had come in about this. You know, if you are working while you're pumping, you should be paid for that time. Employers under federal law don't necessarily have to pay unless they're also compensating other people for the break time, but if you are working while you are pumping. So just to clarify that with this scenario as well. But in terms of the, you know, can people lodge complaints about the disruption? That might actually go to, I think, the undue hardship. You know, is it causing people to have a very difficult working environment? And I think to Jess's point, I don't think it should rise to that level, but I think it would be a case by case basis.
So I'm going to play a little devil's advocate and put in there, what would be the difference in an employer or an employee sitting and eating during a staff meeting and a baby nursing?
Absolutely. I don't.
What?
One difference might be if the worker has her breasts exposed. Um, while under state law, it's not considered indecent exposure to breastfeed. For some reason, when you put it on video, folks tend to be less comfortable, and it sort of opens up new areas for us to think about. But say, for example, you have the video camera pointed at your face. I don't see much of a difference. I don't see much of a difference there. But
Right.
again, you should be able to take those breaks if you need to take those breaks. And if not, if you want to keep working, I think that should be reasonable. But I think it might depend on the exact scenario and why, who is complaining, why they're complaining, and what other alternatives might be available to you that don't hurt your ability to breastfeed and to get paid, right? Because I think that's a very real concern. A lot of folks
Right.
want to work through those breaks because otherwise they're not going to be able to make ends meet.
Exactly. Definitely. Okay, so we have another question that came in. It says, how do unions impact in this equation?
So unions can include in their bargaining the some of the provisions about reasonable accommodations for lactation or pregnancy-related conditions, or just flat out say that you're entitled to break time as needed. There's all sorts of different sort of formulas that I've seen in collective bargaining agreements to address folks getting what they need in terms of lactation accommodations. So I would definitely check if that is in one of your collective bargaining agreements. Most or many, at least, unions also have something in there saying that as a part of the agreement, the employer is going to abide by all applicable state and federal law. So that means if you are subject to one of these laws, you think your rights are being violated, you can't just call, you don't need to call a lawyer. You don't necessarily need to call us, although you're welcome to, but you could also contact your union representative and you might be able to grieve the violation of your lactation accommodation rights under the union process. And that just means that there's an additional person in your corner helping to advocate for you. And I've seen this really often help folks get the resolution they need before situations get really bad.
And lastly, what about undocumented workers and how they fit in this equation?
So with Title VII and the state pregnancy accommodation laws, many of them, Title VII applies to undocumented immigrants. It may be that if there were a court case that they might get different awards of damages than are commonly awarded. So that's one thing to note. But many of the state laws apply regardless of immigration status as well. So that is something to note. And I think particularly what's important to note is we've been talking about, affirmative obligations, but a lot of under these state pregnant worker fairness laws, but a lot of these laws also have anti-retaliation provisions, which means you can't be retaliated even for asking for the accommodation, for using the accommodation, which I think is really important because there's an increased fear about that among undocumented immigrants, which we've seen time and time again. I think I'll speak for a Better Balances helpline. We never ask about immigration status. If someone wants to share that, they certainly can. But I think that's also a reason why our helplines are particularly crucial, because I think a lot of undocumented workers have a lot of fear about going to enforcement agencies, understandably, certainly right now. But as a nonprofit organization, we never share information about undocumented workers, and like I said, don't even ask about it. And it really is a safe place to come to for workers to understand their rights and be able to work with their employers to try to get what they need.
And I agree. Same for Center for Work-Life Laws helpline. And I would note that what you said about folks who are undocumented having access to those enforcement agencies is also true when we're talking about the break time for nursing mothers provision. Undocumented workers are also entitled to overtime, and so they're entitled to those provisions, although we know sometimes it's hard to trust the government with enforcing those rights.
Yeah, and I'll
Happy to
just add,
help if we can add.
this is Galen, that I think that the enforcement under those circumstances is really a problem, and a lot of people don't feel comfortable coming forward for the good reasons that we've discussed. I'll add just that the enforcement agencies often have authority to look into allegations of conduct that would violate the law. Regardless, they can do it on an anonymous basis. So many people don't even, if you don't feel comfortable giving your name or information, many enforcement agencies will actually accept those types of anonymous complaints, and then they have the authority to investigate. An example would be the New York City Commission on Human Rights that was mentioned earlier. Or one of the nonprofits, like Sarah was saying, can raise these issues on the worker's behalf without disclosing their identity. So there are these avenues to make sure that the law gets enforced properly.
Yes. You guys have all given great answers and provided a tons of resources and tools for your toolbox. We want to say thank you to all of our panelists. Thank you for all of our attendees for staying over with us. Please grab these resources and these different tools to put into your toolbox. Reach out to us if you have any questions or concerns. Um, and again, please share your stories with us. Thank you for attending this webinar.